All right, good afternoon. Welcome to Sperian's webinar, GDPR Lessons Learned from 200 Companies Who Got It Wrong. I am joined today by Scott Giordano. He is the VP and Senior Counsel of Privacy and Compliance at Sperian, and I am Eddie Rice, the Content Marketing Manager at Sperian. And just a few housekeeping matters before we begin. If at any time you can't hear the audio or see the slides, please, of course, check your computer's sound and display settings first. But if that doesn't work, please alert us in the chat function. And if we have multiple people with the same problem, we'll know that it's on our end and we'll take the appropriate support measures. Second, the slides and recording will be emailed out to you after we are done. We'll send it to the same email that you registered for the webinar with. And we'll definitely be able to take any questions too. And finally, this webinar will take about an hour with time for questions throughout and at the end. You can use the chat function and we'll find natural places to pause and take your questions. And some of you did submit questions in advance of this webinar, and those will be answered at the end as well, and we've set time aside for it too. And with that, I will go ahead and turn it over to Scott, who will introduce himself, tell you a little bit about his background, and from then we'll start the webinar.
Wonderful. Thank you, Eddie. So I want to welcome you all to our presentation. As Eddie said, please feel free to ask questions throughout this. We'll take pauses and we'll get them. Also, if you've emailed questions, yes, I have gotten them all, and I will make sure to answer them all. I have not edited them, so I'm just going to read them like you wrote them, and so we'll cover those towards the end. But I have set aside some time. So, without further ado, let's get to what I'd like you all to leave if you leave with nothing else. So let's go to the next slide and talk about those items. So item one, I want you to leave with, as of this webcast, as of right now, there's about north of 230 fines that have been levied since GDPR enforcement began. Spain's DPA, I've been very impressed with them this year. They're currently in the lead with about 42 fines. So very impressive, and I know that there was some consternation last year, we'll say, about the lack of GDPR fines and enforcement actions, but it's really picked up, and I expect to see that continue because much of the work that really is preparatory for issuing sanctions has already been done. And so as a result, we'll probably see continued fines for the next couple of weeks until I imagine investigations start slowing down. So second thing, most of the failures I'm going to describe here are really attributable to three things. Basic security and privacy failures, and I emphasize the word basic. Secondly, ignorance/indifference regarding the GDPR, and we'll see that in a little bit. And in some cases, just bad attitudes. I'm amazed at some of the bad attitudes I've seen, and as a result, the penalties have ensued. So we'll talk about that. Also beware of non-financial penalties. It's very easy, and sometimes there's an incentive to just look at financial penalties, but the non-financial ones can be far worse. So in many of the cases I'll describe in a little bit, the DPA, the supervisory authority, what have you, issued orders saying you must do a long list of things. In one case, 20 different things were issued by the DPA. So that can get pricey. And in fact, the FTC did the same thing to Equifax in their settlement. Equifax is going to have to spend about $1 billion or so, a billion with a B, as it were, over the next 5 years to do remediation. So the net of it is that non-financial penalties can be just as bad as financial penalties. Next slide. Let's talk about a couple other things I want you to leave with. Next up is that organizational controls are just as important as technical ones, and they're not the cool things that we all deal with, like encryption and multi-factor authentication and firewalls and all that stuff. It's policies, procedures, breach notification plans, data classification scheme, all those things that are not terribly exciting but are super important, and they're cited a lot in these orders from supervisory authorities. Next is that third parties are significant risk threat vectors. And if you follow my webcast, you know that I talk a lot about third parties. I'm not going to go into that in a lot of detail today. I want to remind you all, though, that typically if you get into trouble, third parties likely involved, either because they're doing things they shouldn't be doing with your data, and they are leaving the door open for bad guys to get in. So more of that in a future webcast. Security plus privacy equals data protection. And this is also a theme that if you spend any time on my webcast, you know I really harp on. But data protection is a discipline in and of itself. You have to have the security and the privacy folks all together, all in the same team, working side by side. This has been historically how I've worked in my career with the security teams, and it's enormously successful. I will probably do a webinar just on this topic at some point during the course of the year. And then finally, understanding where personal data lies in your information ecosystem is key to compliance success. And again, this is something I talk about a lot. If you don't know where the data is, it's really going to be difficult, if not impossible, to protect it. So, and finally, before we go on to the first case, I did pick a lot of examples that are big dollar cases because people want to look at the big dollar cases, but sometimes the smaller dollar cases are equally, or if not more so, important because of the circumstances. So just because it's a small dollar value case doesn't mean it is unimportant, as we'll see. So I'm going to do a natural break here. Eddie, any comments or questions coming in before we go into Cathay Pacific?
Not that I see yet, Scott. We're pretty much good to go. And before we move on, though, would you mind giving just a little bit of your background?
Oh, sure. I'm sorry. I presume everyone knows who I am. I'm an attorney, been an attorney for almost 25 years now, specializing in data privacy and security law. I've been with the team here almost 2 years. Before that, I was with Robert Half Legal and with Protivity doing GDPR projects. And so spent a lot of time knee-deep in GDPR, and hence why I love talking about all things GDPR. So now that's my background in a nutshell.
Okay, fantastic. We have 2 questions actually, Scott, that came in right as you started to speak. First, are you going to be participating in the Virtual Security and Privacy Forum in May?
Well, if it's the one that was supposed to be in DC that Dan Stolov is putting together, yes, I'm going to be in that one.
And then the other question is, any detail on which business sectors the fines were issued?
Yes, I'll talk about all the sectors here. It's going to be fairly obvious, but I'll talk about it. The short answer is it's not confined to any one sector. Basically, any business is subject to this, as we'll find out. Ones that tend to be magnets for trouble are ones that are consumer facing. So public utilities, for example, are just great magnets for DPA fines, but we'll see that in a minute.
All right, go ahead.
All right, so Cathay Pacific. This is, yes, the airline. And if we go to the next slide, this is an airline based in Hong Kong. It's got operations in the UK. And in 2018, they carried about 35.5 million passengers. So not a small organization by any measure. And from October 2014 to May 2018, Cathay Pacific's computer systems, quote, lacked appropriate security measures. And you read that right, so almost a 4-year period. So yes, that's exactly it. And it just happened to find this in May of 2018 when GDPR was coming down the line. So personal data of approximately 9.4 million customers were exposed, including passport numbers. And so Cathay reported this to the Information Commissioner's Office, the ICO, that's the UK's Data Protection Authority or Supervisory Authority, in October of 2018, so about 5 months or so after they found the breach. And the ICO found, and I'm quoting here, multiple serious deficiencies, setting 12 different failures, and which I'll cover those in just a minute. Fine them £500,000. Now that's the max they could be fined under the Data Protection Act of 1998, which was the previous law before GDPR. So that was the limit. If it was GDPR, it could have been as high as £470 million. So a big difference. The primary GDPR article here is 32, and this is cited consistently in the case studies here. Now, they didn't cite 32 per se, they cited DPP 7, Data Protection Principle 7, which is organizational technical measures for protecting personal data. So same thing, same idea, it's just that now it's called Article 32 in GDPR. So I'm going to read some of these. I'm not going to read them all because I don't want to spoil the surprise for you all. You got to read this case, it's remarkable. But 6 of the things that went wrong here. Database backups were not encrypted. An internet-facing server was breached, and that server was using a 10-year-old OS. Okay, so I'm sorry, a 10-year-old vulnerability, but which is just remarkable in and of itself. It means this thing just never got patched. There's an administrative console that was publicly accessible via the internet. That's a huge no-no. One server used an OS that was no longer supported by the vendor. So again, great opportunities for not getting security patches. There was also no server hardening. When we say hardening, we mean you're not closing off ports that no one's going to be using. You don't shut down services that no one's going to be using, things like that. Just basically eliminating your attack surface or minimizing your attack surface. Also, the network, if you VPN'd via the network, you didn't have to use MFA, multi-factor authentication. And again, if you've listened to my webcast, you know I love MFA because it's a lot of bang for the buck. It could be a token of some type. We have MFA tokens on our cell phones. Way back when they were RSA tokens. But the point is, MFA is huge. You get a lot of bang for the buck. They didn't have it. And the problem is when you have a VPN and you don't have that kind of authentication, essentially you're going to be VPNing in all your problems to your employer, for example. So just not a good idea. And I'm not going to read the other 6. I want you to read them because it's pretty compelling stuff. All right, let us go to the next one. Let's go to Google here.
Sure, Scott, 1 second though.
Yeah.
There are 2 questions.
Sure. Sure.
First, has there been any history of whistleblowers reporting to DPAs?
Is there any history of what reporting to DPAs?
Of whistleblowers reporting to DPAs.
Oh, whistleblowers. Oh, that's a great question. I have not read of any cases of a whistleblower, as we understand them here in the U.S., reporting to a DPA. So no, because you don't. And I presume by whistleblower, the person with the question means someone on the inside. And the short answer is I don't know. It's a fascinating question. I should run that to ground. That would be an interesting topic to take up for a blog post or something. So the short answer is I don't know.
And the second one is I am a billing company located in the U.S. I receive data from 40 states, which includes patients' data from Europe. What are the risks if I don't follow GDPR?
Well, and I'm going to cover this towards the end as well, but let me give you the super short answer is that if you have operations in the EU and you run afoul of EU law, they are definitely going to bring the hammer down on you because patient data is Article 9 data, meaning special data. It requires explicit consent to be used by from the data subject to be used, etc. So the net of it is that you have a presence over there, you're going to be in trouble. If you don't have a presence over there, then it opens a bigger can of worms about the DPA coming to the U.S. and asking the FTC, or in this case, the DHHS, to potentially bring the hammer down on you. The net of it is your exposure has got some potential there, and it's something that needs to be looked at.
All right, that's it for the questions for right now. Let's go ahead and go on to our next slide.
Yes, let's go over to Google here. So Google in the news again. This is the Swedish DPA. I won't try and pronounce the name of the Swedish DPA, but this is also a recent case. And if we go to the next slide, essentially here's what happened: is that back in 2017, several Swedish data subjects, asked Google to remove some links to their personal data. And there were things that were either outdated, trivial, not relevant, superfluous, whatever you want to call it, and evidently had some reference to something that was either criminal or otherwise bad. It could be someone got in the newspaper because they were caught drunk driving or something like that. That's the inference from this whole thing. So Swedish DPA ordered Google to be forgotten, to remove the links here. In 2 cases, Google didn't comply. In one, they just simply didn't remove the link. They just said, that's that, we're not removing the link. The other one, and this is really strange, Google told the website that had the story in question who the name of the requester was and how to circumvent the right to be forgotten order, takedown order by the Swedish DPA. So again, not particularly, I think, a good course of action. And so the DPA fined Google 75 million kroner, which is roughly 7 million euros. And Google, of course, said it would appeal. We'll see if that happens. This is, again, fairly recent, last couple weeks. Another reason I chose this. So what are the articles involved here? This is where I want to zero in on some of the articles because I think it's really important. Article 5 is your basic privacy principles, and this is the #1 cited article in all of these cases. And it's the case that it's cited because it's so easy to get someone to violate someone on this article, because it talks about basic privacy principles like fairness and lawfulness and transparency and all those elements. So when you read these cases, you'll find that Article 5 is cited and it's easy to violate. So for example, Article 5.1b talks about personal data processing that's incompatible with the original purpose for which the data was collected. Okay, so that's one fairness principle. The other one is Article 5.1a, talking about circumventing the right to be forgotten by essentially preventing people from exercising their right to request removal. So whenever you have one violation in one area, like not honoring a right to be forgotten, then essentially you're also violating Article 5. So an easy one to get caught with, and you'll see that in almost all these, if not all of these. Second one is Article 6. This is the legal basis, and this is #2 cited article violated in these cases and other cases I read. And that's so because you have to have a legal basis to process data, otherwise you can't do it full stop. And just saying you have a legal basis, just saying, for example, you have legitimate interest is not enough. And in fact, next case we'll talk about legitimate interest and why it's not all that you may think it is. Also, Article 9, that is personal data, sensitive personal data. Again, the inference here is that there was something very personal that fell into Article 9. Article 9 talks about things like healthcare, sexual matters, religion, politics, trade union membership. So things that are sensitive issues, that was cited. Article 10, which is not cited much, that's about criminal convictions. So again, the impression is that someone got caught doing something and it wound up in the newspaper or some other site, and they wanted to get it removed. Article 17 is right to be forgotten. And then what you'll find is Article 58 and Article 83, they're cited a lot in these as well. And Article 58 essentially says that the DPAs have the power to bring the hammer down on offending parties like Google. Article 83 is the formula for crafting what the fine will look like. So again, you'll see these. I put these in the secondary column because it's not the reason that Google got hit, but it's cited with some regularity. Questions, comments, Eddie, about this or about anything?
We do have a question that's related to the CCPA. I'm
Sure.
still seeing a number of websites set up, whereas they still default to users opting out. With CCPA, are you seeing this change, or is this still an issue in your mind?
I'm not seeing the change because at this moment, it's still opt out, not opt in. Whereas obviously GDPR, everything's opt in, unless you've got another legal basis. CCPA is opt out for the moment. Now CCPA 2.0 is largely opt in for certain kinds of data, actually a lot of kind of data, if you will. And again, we'll do an entire webcast on that in the next couple of months. But the net of it is that no, I'm not seeing changes for CCPA. People are just essentially trying to keep opt out rather than opt in, because basically when you ask for opt in, it really shrinks the population. So that's the short answer.
All right, you ready to go to the next slide?
Yeah, let's go to Royal Dutch Tennis Association. And again, I'm not going to try and pronounce the how this is natively. I'm just going to call it the Royal Dutch Tennis Association. Again, not a big dollar case, but an interesting case. So let's go to the next slide and talk about this. So there's not a lot to this case in terms of fact pattern, but there's this idea of legitimate interest. So here's what happened. This Royal Dutch Tennis Association sold name, gender, address to about 300,000 or of 300,000 members to one sponsor and about 50,000 others without consent. So flat out sent these, and the folks got called or received emails or regular postal mail or what have you. Again, this was evidently a surprise to these folks. So someone complained to the Dutch DPA, which did an investigation. As you see, I tend to post the documents on the right of the screen. And the association got fined 525,000 euros. So again, not a huge amount of money, although it's probably huge to the association, but still significant. And so the deal was that the association's position was they said, oh, we've got a legitimate interest. And we're going to talk about that in just a minute. So the primary GDPR articles 5 and 6, not surprising again, principles and legal basis. So those are easy gotchas. Second one is Article 17, right to be forgotten. So let's talk about legitimate interest, because this is probably one of the most misunderstood areas of the entire GDPR. Just saying you have a legitimate interest doesn't mean you have one. It really, as a practical matter, you have to do what's called a legitimate interest analysis. It's a balancing test based on a document that came out way back when. The Article 29 Working Party put this together. It's called Opinion 6 2014. That's Opinion 6 2014. It is a must read because it shows you the formula for legitimate interest analysis. It's very easy to say, oh, I've got a legitimate interest, and if you haven't documented it, or if you've documented it after you've gotten caught, then you're really in trouble. And I saw this happen a lot in the run-up to GDPR. A lot of companies simply said, oh yeah, we've got a legitimate interest, and they didn't document it, and they were doing it after the fact. So here's the way this works. And again, I could do an entire webinar about it, but I'll just give you the Reader's Digest version. The interest must be real and present that the data controller has. So it can't be something you're thinking about doing. It's got to be something you're doing now or really want to do like immediately. It's got to be something that's already lawful, permitted by the EU and by your country. And then you have to do a balancing exercise. So you have to look on one hand, what's the nature and the source of legitimate interest, and then you'll contrast that with the impact on the rights of data subjects. And then you'll ask yourself, well, what's a reasonable expectation of data subject in light of the relationship? And that's really going to tell you which direction your legitimate interest falls. In this case, you could argue the tennis club could have just asked permission from their members. They could have put it in membership contract. Typically, whenever you join these things, there's a contract you have to sign. So they didn't do those, which doesn't look very good. And so then claiming you've got legitimate interest later, it just doesn't work very well. So as a practical matter, that was not the correct course, and it's just a good lesson for all of us that you really have to think through legitimate interest if you're going to use that. So that's Royal Dutch Tennis Association. Any comments, questions come in?
There is one. This is on do not track settings. So
Yeah.
how is the EU treating do not track or DNT browser settings? Is DNT the equivalent to opt out? And do application servers process DNT settings on websites?
Oh boy, those are wonderful questions. The short answer is I'm going to have to go look it up. I knew it at one point because there's actually a separate law that governs this. There's the e-cookie law that governs do not track, and I need to go run that to ground. I used to have this memorized back when I was doing GDPR projects. So the net of it is I will find the answer, and we'll share it with the audience on next webinar, and we'll cover it then. So yeah, my apologies. I don't have the right answer memorized.
All right, you ready to go to the next slide, Scott?
Yeah, let's roll the next one. So this is Tim SPA, okay, and we'll go right to the case here. Tim as in Telecom Italia. So Telecom Italia, this is a giant telecommunications company, and between 2017 and 2019, they made telephone solicitations, so phone calls essentially, to millions who were on Italy's do not call registries or otherwise indicated that they did not wish to receive promotional calls. And in fact, one person was called 155 times in a given month. So if you think you guys are getting spam calls, these guys really were just laying it down. So the affected individuals, not surprisingly, complained to the Italian supervisory authority, the Garante. And so the Garante did an audit, did an investigation, and it is lengthy, and responded with a 27.8 million euro fine and 20 corrective measures. I mentioned earlier about how important the non-financial penalties are. In this case, 20 corrective measures. I'll go over a couple of them, but again, definitely want you guys to read the report. Also, the privacy fraud unit of the Guardia di Finanza got involved. These are the guys that fight money laundering and drug trafficking. They also evidently address privacy fraud, and we'll touch upon more about that in a minute. So let's go through all the articles. Here's a long list of articles that got violated here. Not surprisingly, 5 got violated, as is consistent throughout this whole thing. 6 did not. 6 was violated because of the lack of consent or the lack of correct consent. And this is important. I really want you guys to understand that when you rely on consent, you have to demonstrate that the consent was legitimate, that the people understood that what you were asking of them, what you were going to do with their personal data. Here's the killer. When you have one checkbox and you've got 10 different uses or 15 or 20 different uses, and you try to do that, it's going to fail. And these are battles that I unfortunately had back in my run-up to GDPR days with clients when they said, oh yeah, we're going to have one checkbox for everything. It's a great way to run afoul of GDPR, because there's no way people are going to be able to understand exactly what you're doing with the data when you check one box for everything. It doesn't work effectively. It's not legitimate consent, and it's, again, an easy way to violate the GDPR. So that's why, and Article 7 talks about the nature of consent. So they actually have a separate article that just goes into great length about what consent has to be. Again, I'm not going to spend an entire session on just consent, but I want you all to know that this practice of one checkbox for everything just is not going to fly. If that's what you're doing, especially on an app, I see this all the time on apps. If that's what you're doing now, time to make some changes, because it's too easy to get violated by the DPA on that. Article 17, oh, I'm sorry, before I go to 17, Articles 12 and 13. So this is the idea of transparency of information and what's being collected of you. Evidently, Telecom Italia had 3 different apps that were involved in this. They were audited, and apps are a great opportunity to get into trouble because they weren't sharing information about what was really being done with the information that Telecom Italia was collecting. So they were collecting this information, evidently not telling people they were going to use it for telemarketing. So that's a huge no-no, and that's why 12 and 13 were involved. It's about information transparency and about sharing information to the audience, to the data subjects, about things you're collecting. So that was a killer. Article 17, right to be forgotten. Again, that gets cited quite a bit. Article 21 is marketing. And what's interesting is GDPR is a separate article just on direct marketing, and gives you the ability just to tell someone, stop direct marketing to me. That's it. I don't want to see any more. Again, it's interesting they broke that out separately, and it's a fairly lengthy article. I definitely recommend looking at that one. Again, easy to violate if you're not using consent correctly. Article 32, policies and procedures. So I mentioned earlier in the discussion here that Article 32 can get violated very easily if you don't have policies and procedures to prevent bad things from happening. So it's not necessarily about technical controls, although that plays a big role, but just regular policies and procedures. Acceptable use policy, probably the #1 policy that every company should have, because if you're telling your employees what they can and can't do and how to do it, it just limits your exposure. I see a lot of companies that don't have them, or they've copied and pasted one from another company and don't really understand what they're asking their employees to do. And more times than not, employees aren't even acknowledging the receipt of it. So really basic policies and procedures, super important for preventing fines from the DPA. Couple other things I want to touch upon. Corrective measures. Again, I'm going to just touch upon a couple of the corrective measures because there are 20 of them, and I don't want to spoil the surprise for you guys. I want you all to read this. So one was just stop calling people on do not call lists. That was a corrective measure. Okay. Evidently, it takes some effort just to tell people stop doing that. Stop using customer data obtained by those apps. I mentioned there's about 3 different apps that were involved. They just gave a stop order. Stop using that data that you've collected. Third was faithfully update the do not call lists and communicate that with all the folks in marketing. And when I say the folks in marketing, I mean they likely outsource this, but communicate that with marketing and all the third parties that you were involved with. 4 was allow customers to allow customer access to discounts and other things that they were offering, that Telecom Italia was offering. give them access to discounts and things without sharing their personal information. So evidently there were sweepstakes and discounts and other things they were using to get customer information, and they were ordered to stop doing that. Also, go back to the apps themselves and make sure that you're communicating what you're actually doing with the customer's data. So go back to the app, fix the problems with the app or apps in this case, and get those all set up. And then update policies and procedures with respect to essentially warning the company to the folks in compliance about what's going on with the practices we described earlier about telemarketing, telesoliciting, what have you. So just different policies and procedures that have to be updated. And again, this is very common for Article 32 to ask companies that they need to take a hard look at what they're doing with their just basic security procedures. So I'm not going to go into much more detail. I will say this: they also found fault with the breach notification procedures that the company had, and also poor privacy by design. So those of you probably familiar with privacy by design, it's usually called private data protection by design, but it's the same idea about minimizing the opportunity for misuse of data. Okay. Comments, questions, Eddie?
Yes,
Anything
Scott, there's a
coming
few
in?
questions ready for you. First one
Sure,
up.
let's roll.
I work in technology for a construction company. Technical protection is the easiest part, in my opinion, but curious what you would suggest for employee and user training on the do's and don'ts.
Well, I mean, the good news is that there is a lot of do's and don'ts in acceptable use policies, AUPs. What I would do is, if you want a cheat sheet, is if you just get on your favorite search engine and go look acceptable use policy, you'll get, there's a bazillion of them out there floating around, and they all list, quite literally, do's and don'ts. List what you should not do with your data and with your laptop, your desktop, or your mobile device, what have you, that are great. And they also list the things you should do. So, for example, on acceptable use policy, they'll tell you about all the things you shouldn't be doing with your laptops, like, for example, using your work laptop for personal stuff like putting games on it or letting your kids on it or what have you. So, and they give a lot of really good stuff. And again, this is something that your company likely should have anyway. So I would go look at that first. I think you'll find a lot of good stuff. And again, AUP, #1 policy that people don't use or companies don't use, they really should. You'll get a lot of bang for your buck.
Next question, Scott. Can you talk about clinical trials in relation to GDPR violations?
Oh boy, clinical trials are such a specialized area. I have not spent much time, I think, at all with them. And also, there's the equivalent clinical trial exceptions that CCPA has. I won't say necessarily it's an exception, it's an application of it. There's a lot of that. Unfortunately, I'm not an expert with it. So what I can do, again, for the other questions I can't answer now, I'll just write up a summary and I'll share it with the audience on our next webcast.
All right, the next one up has to do with GDPR and Brazil. Will any GDPR articles being prosecuted map to Brazil's LGPD coming this summer?
Yes, LGPD. I think we're going to do a webcast on that later probably in the summer, quite literally, when this comes up. So which ones map to which articles? Short answer, again, I'm 0 for 3 on some of these questions. Short answer is I don't know off the top of my head. I do know that I'm sorry, I'm going to mangle that one. But the Brazilian GDPR is heavily influenced by regular GDPR. So we'll do a one-to-one mapping project probably late spring, early summer, and we'll have a webinar for you guys in the summer so you can see that. And I'll also find an expert that just knows it locally, so that way we'll get some local knowledge there.
Great. We've got a conflict issue. How do you address issues where there is a conflict between GDPR and other regulations and statutes?
You have to choose the law you wish to violate, and I don't mean to be glib when I say that, but that's literally where we are. So if you, for example, in the U.S. have to hold data for 7 years for, say, broker-dealer data, and you're doing business in the EU, and they say, sorry, right to be forgotten, remove all my data, then you really have to choose which law that you're going to violate, and there's just no way around it at this point. Some people have suggested that, well, this is you can use the Article 6 exception for legal compliance. Problem is that only applies to EU laws, does not apply to laws outside of the EU. So citing broker-dealer laws here in the U.S. is not going to help you, and there's other ones like that as well. So the net of it is you get with your lawyer and you decide which law you're going to violate, and that's it. And I hate to say that, but I've had clients bring me into those discussions and ask me what I thought about it. So that's the best you can do at this moment.
And on the topic of GDPR fines, has there been any fines assessed to any organizations that do not have a presence in a GDPR country?
Boy, there was the fine that went to Cambridge Analytica, but I think that was pre-GDPR. The ICO went after Cambridge Analytica in Canada, and I don't think, they also went after them criminally, and I don't think anything ever came of that. But as far as GDPR itself, I'm not aware of any yet. And if anyone in the audience is, you can feel free to email me. I'll run it to ground. But typically, all the cases I've studied have always been some organization within a given country, rather than an American one, for example, with operations in the EU.
All right, and we'll do one more before the next section. With the pandemic, a number of companies are sharing data across borders, possibly without the proper data sharing language in place. Do you think this will be a problem or an exception due to the current circumstances?
Oh, excellent question. It's funny because I'm going to be doing a webinar on the 31st just on this issue. The net of it is that unless the regulatory authorities create a waiver for certain things, the potential is still going to be that you'll be punished for sending data across borders that you shouldn't have, meaning that you didn't get the appropriate legal basis, and then there's not a data transfer mechanism in place. Remember that there's always two steps to getting data out of the EU. You have to have a legal basis to begin with, and then you have to have a mechanism to get it out, like model contract clauses, for example. People sometimes will get the first, but just ignore the second. So just keep that in mind. If you're relying on consent, you better have really good documentation on consent and have people understand exactly what they're getting into. Here in the U.S., there's been some HIPAA waivers, not as much as people I think like to think. So the net of it is that assume you're going to get punished if you're sending data out of the EU without a legal basis or data transfer mechanism.
All right, let's go ahead and continue the regularly scheduled webinar. Here we go.
All right, so Annie Gasaluce, or EGL. This is a big utility in Italy. Let's go to the next slide here. And this is not terribly different from the case we just discussed. So Annie Gasaluce, they're a public utility. Between 2017 and 2019, made telephonic solicitations to millions who are on Italy's do not call registries or otherwise indicated they did not wish to receive promotional calls. Boy, does this sound familiar. So as per usual, the affected individuals complained to the Garante. Garante made an investigation and found all kinds of things. One, the calls were made without consent or checking the do not call list. So we're back to Article 6. Not terribly surprising. Also note policies in place to prevent this. Again, we saw that in the last case. Also excessive data retention time. So I thought that was interesting. One thing I didn't see mentioned previously, this idea that Annie was just using data that had been around for quite a while. Interesting, there was two different fines here. So if we go to the next slide, we'll talk about the second fine. So I thought this was interesting. The Garante found that Annie was automatically creating new contracts for customers without their approval, and that violated the principle of correctness, accuracy, and updating of personal data. So not an unprecedented situation here in the U.S. I think we had a bank that was opening up accounts for people without their permission. This is a similar scenario. And so here, the Garante responded with two fines. So €8.5 million fine for the original telephone solicitation issue, And then 3 million for the automatically creating contracts without permission of the individuals, because effectively it's a misuse of their personal data. We probably would look at it a little bit differently here in the U.S. We use different theories legally, but they use this, and that's not uncommon in the EU to use a privacy theory to punish things that are not 100% on privacy. Banking is a great example of that. And so they put down also a mandate for corrective measures. And when I say corrective measures, in this case, setting up policies and procedures to create alerts to compliance and to other responsible parties for alerts for improper activities. So very similar to the previous case. I brought it up because of this novelty, if you will, of punishing them for creating accounts using someone's personal data effectively to create a new account. So a very novel way of doing that, and I wanted to share that all with you. Otherwise, very similar to the previous one, and the Grante is on fire this year for putting out some serious fines. Okay, let's go to the next case. This is 1&1 Telecom, and this is the 1&1 Telecom you're probably all familiar with. If you've done any web hosting for your websites, likely very familiar with this. You've seen the ads, I'm sure, dozens of times. So let's go to the text of the case here. So 1&1 telecommunications services provider, again, very big on hosting. And the issue here was that anyone could call customer service, and just by giving them a name and the date of birth could get all the information that 1&1 had on the customer. So pretty glaring weakness. And evidently someone decided that was not a very good idea and called the authorities. In fact, they called the Federal Commissioner for Data Protection and Freedom of Information, the FBI. This is the national privacy police, the national DPA. Also in Germany, each lander, each locale has their own DPA. But evidently the people that complained went after using the national DPA. And so they did an investigation and came back with a €9.5 million fine, which is pretty hefty. They considered the authentication policies and procedures as an organizational measure to protect personal data, which is why Article 32 is being cited here. So I know you guys have heard this umpteen times, but it bears repeating that it's easy to say, oh, you don't have basic information security, and that's true. But here the case was not the mechanism, not the firewalls and so forth. It's just basic authentication and things that are not terribly exciting, but are part and parcel of information security. So good news is that 1&1 cooperated during the pendency of this whole investigation, and that probably got their fine knocked down a bit. But overall, the FDI decided to give them a hefty fine, and also start an investigation to other telecom companies, web hosting companies in Germany. So this is probably the most important point to take from this case study, is that if someone in your industry gets a investigation and a hefty fine, probably a good idea to bring up that scheduled audit right now and get rolling and see what kind of weaknesses you might have that need to be squashed before the authority comes knocking on your door. So that's 1&1 Telecom. Any comments or questions from the audience, Eddie?
There is. This one's a little bit long, but I'm going to do my best to get through it.
Okay.
So here it is. How can an organization control or monitor situations where a potential loan application accesses a U.S. website in order to submit an application to finance the purchase of a residential property in the U.S.? For example, we have found that the submitter enters a U.S. address, quote unquote, which typically is the address of a U.S. company they work for. It is difficult to know that the individual is not in the U.S. at the time of electronic submission.
Yes, this is a tough nut. The short answer is, aside from really good geolocation, which I don't know if even really good geolocation would help you, because if you're just getting an email from someone, I don't really know how you could geolocate that. When I was trying to solve these with clients, these problems, if you had a website, websites can do a fairly good job of geolocating folks. There's good technology to do that. Also, apps also have this technology. I think that's the way I would go, is is instead of relying on an email from someone who's an applicant, perhaps forcing them to authenticate against a website or using their mobile app to authenticate against someone and doing geolocation that way to get an idea of where someone is at the time that they're making the transaction. I think that was the solution we came up with, and just had to just dump email as a mechanism and had to use working through a website, maybe through a website chat system or something like that as a way to get an idea of where they are when they're applying for this loan or otherwise they're involved in a transaction. So another reason why dumping email as a communication medium is probably a good idea here.
Great, and we have another one before we go to the next section.
Sure.
European companies tend to follow ISO 27000 versus US companies tend to implement NIST as their cybersecurity framework. While both are very similar, do you find regulators rather see companies use one over the other, or are both frameworks acceptable when defining your cybersecurity program?
I've never seen a regulator choose one over the other and say, oh, you used CSC Top 20, we don't like that, we're a ISO 27K shop. I've never seen that. It is more important to pick a security posture, a security framework or standard that you know you can actually meet the standards of, rather than pick one that maybe everyone else is using, but it's not appropriate to you. So that's why, and I'm a big fan of NIST. I just did a write-up on privacy framework. I'll share that with you guys probably in a month or so. Also, we'll do one on the security framework, the CSF. Net of it is that whatever you choose, do it well. Don't bite off more than you can chew, and be able to demonstrate that whatever you've chosen to do, that you've done it well and you've got the evidence. That's going to go a long way to compliance vis-a-vis just picking whatever the most popular privacy framework or standard is at the moment.
Two things. First, a member of the audience wanted us to know that geolocation can be fooled by VPN proxies. And second, Scott, we have about 15 minutes left. Would you like to go ahead and just get to the Q&A part of the questions that were submitted via email before this webinar?
Yeah, sure. I think that's fine. And to the audience, yes, I realize that you can use VPNs to do all kinds of stuff. I totally get it. I guess the point I'm trying to make is that if you want to stay in compliance and get an idea, you have to make a best effort. And if geolocation technology is the best you can do with what we've got, then you roll with it. I know people are going to try to circumvent that with VPNs. I get that. I know that the Netflix companies are always battling that issue. So the net of it is just do the best you can. It shows the effort. You don't have to be perfect. You just have to be sincere. Okay. Let's go to your questions answered. And these first two questions I'm going to answer as a unit. So what international law mechanisms allow supervisory authorities to enforce these fines? And presumably you mean the authorities in other countries like the U.S. Also, is there any additional clarity on enforcement to U.S.-based companies or entities, and would the U.S. government uphold? So I'm going to answer these as a unit. Essentially, there's no mechanisms at this moment that are GDPR specific that allow them. For example, there's no civilian, okay, as versus criminal, there's no civilian mechanism where a GDPR authority, say the ICO or the CNIL or what have you, can come in and punish someone in the US for things they've done in the EU directly. They can, of course, as I said many times, lean on the FTC or on DHHS if they're collecting perhaps special medical data or special data or criminal data or things like that. In theory, they could come in and lean on those politically, which is not unusual, but there's no legal mechanism. That doesn't mean that you're in the clear if you're getting in trouble with the EU. So I wouldn't recommend that deliberately. But at this point, there's just no mechanism that may come with a free trade agreement or something like that vis-a-vis the EU. The third question here is, should individual associates start thinking about purchasing malpractice insurance to mitigate against personal fines? I think the answer here is no, and here's why. If you already needed insurance, say E&O insurance, you probably already have it. And if you do, then you should talk to the carrier and see if there is any kind of danger of personal fines for GDPR violations. Really, there's only one article GDPR that is really in doubt, it's the one about having a personal representative appointed in the EU if you don't have a presence. And this is, and to my knowledge, never been run to ground. So the net of it is that I personally would not worry about having malpractice insurance. If you need it in other contexts, then again, talk to your insurance carriers and see what's covered under it for things like this. Fourth question here, we are buying a company's offices are mainly in the EU. What liability do we have for anything that might be seen as a violation? Wonderful question. The short answer is potentially unlimited liability. And I say that because under EU law, you can have a joint and several liability for this company, depending on the degree of control over which you have. So if you're able to direct day-to-day operations, and most companies in the US would likely do that, I know that was my experience certainly, then you're going to have the joint and several liability. So yes, the liability rolls up to you, and in principle, the EU could use your annual turnover, as they call it, your annual revenues, as a basis for a GDPR fine. So I would definitely make sure that this subsidiary is well versed with GDPR law and compliance and was with the program, because they could be a major vector for fines and other penalties. Okay. Number 5, how does CCPA define and treat data controllers versus data processors? Essentially, under CCPA terms, data controller is a business, and a data processor is a, oh God, now it just escaped my brain here. It is a service provider, I apologize. So essentially, you either have data controllers and their contractors, or you've got, data controllers or service providers. And if you as a company have control over what happens with the data, so purposes and means, as we say, then you're effectively a data controller or co-controller. Otherwise, you're a data processor. And unfortunately, CCPA really doesn't spend a lot of time on data processors, on these service providers. It mentions them a bunch of times, but doesn't really lay down a lot of law. Essentially, it's all about the business, the data controller. So that's really where the distinction lies. And when we do the GDPR versus CCPA webinar next month or so, we'll dig into that a little bit more.
Great. Before we go to the next slide, because there are more questions, yeah. Scott, another one came in. This is about the cybersecurity insurance one. Can cybersecurity insurance be used to offset fines, or is it still true that most countries will not allow companies to use that insurance to address fines?
The latter. Most countries, including the U.S., won't allow you to use insurance to offset fines and penalties and things like that. Because you think about it, if they were, then companies would have the incentive to be more relaxed with respect to things like that. So that's why they just don't allow that.
All right, that's good. That we're good to go on the audience submitted questions. We're on to the next slide. Okay.
So how do I make people understand the real cost of a fine if GDPR fines are so weak? Well, as we saw here today, a lot of the fines were not weak, but even the ones that were would still be pretty oppressive in the sense that they typically mandate certain things to be done. So you saw in the one case, the Telecom Italia case, that there was 20 different mandates that had to be done. Certainly, there was about a dozen different weaknesses cited by the Cathay Pacific case. So you'll find that almost in all of these GDPR cases, that the DPA is going to mandate changes. And this is typical here in the U.S. The FTC does this in every case. I've never seen one where they didn't mandate some kind of change. It's usually annual audits and annual reviews, and for the next 20 years or so. I mean, quite literally. So that's where the real cost is, in all the mandates you've got to do, all the business disruption, all the stuff you've got to buy, et cetera, all the people you got to hire. So I think that's the better way to go, is to highlight the mandates that are in some of these cases here. And it's well worth the read, so highly recommend that. Next one up is, what data protection, privacy regulations, or law has gone nationwide? The best way to describe this is, think about states where a lot of business gets done. We've got California, we've got New York, you've got the SHIELD Act that just went live this month in New York. It's not really a CCPA clone, it's fairly narrow, but it covers everyone basically in the US, because you don't even have to be a business. If you just just, and you don't even have to use the data of someone in New York, you just have to look at it. So it's a very low threshold. I think people don't appreciate it, that SHIELD Act is basically gone nationwide. It's captured everyone in the US. And it requires breach notification, basic security and privacy controls, things you would expect. So that's nationwide. CCPA is nationwide, and CCPA 2 will be nationwide and more or less permanent. So more on that when we have our webinar. Are there any documented industry thresholds when the combination of secondary PII elements, when combined, should be viewed as PII? Short answer is no, and I hope there aren't any. And here's why. Because the minute it's published, it's going to be obsolete because of the nature of big data and big data analytics. Once you start looking at so-called secondary PI elements, it's very easy to infer all kinds of stuff. I did a talk a couple years ago at IATP at one of their events. I did this whole talk just about connecting the dots using inference and how easy it is. And if I can dig up that talk, I'll share it with you guys. The short answer is very easy to infer information about folks with a little bit of data. So I don't see any thresholds, and I'd be suspect of them if they were published. Regarding CCPA coverage, is 25 million revenue limit for CCA specific revenue in California or total revenue? We still don't know. This is something that's mysterious. Why California AG is not opined on this, I don't know. I'm holding out hope for the end of the year, or at least before July 1st, we'll get some insight on this. But right now, we don't know. I would just assume 25 million is your global revenue. That way, you don't estimate the wrong way. Has a certification framework been developed? No, there has not. So if you are planning on using a framework, highly recommend the privacy framework. Again, I'll publish a document on that probably this month or next month. Very, very, very good bit of work by NIST based on their cybersecurity framework. It exists on its own, or it can be used with cybersecurity framework. Highly recommend it. Great, great document. And finally,
another question came in, Scott.
Oh, let's roll it.
Can you speak to GDPR applicability for U.S. entities that send data to cloud storage providers located in the EU? If the data resides and is stored in the EU, is it subject to GDPR?
Yes, it is. And this is Article 3. I'm trying to do this from memory here. I shouldn't be, but it's Article 3 something of GDPR. Basically, essentially, you're putting the data over there. It's going to be subject if it's on EU territory. So that's a definite yes. So if you've got data that you don't want highly regulated, that's not the place to be locating your server. Okay, so we have one final, at least mailed in question. It's long. I'm going to read it, so just bear with me. I did not edit this. I just broke it up so that it's easier to read on the screen here. So my company does not collect or control PII. We are a processor. We have over 2,000 partners, other processors that we engage with to perform services. I'm executing GDPR compliant DPAs with all of them. Good for you. About a dozen of these so claim they are actually controllers because they control the means of processing, and they ignore the fact that the purpose of processing is defined by contract. These are Fortune 500 companies whose business models include selling the PII of data subjects to vendors. Oh boy, you've got a problem here. And we'll go to the next screen. So, for example, Nationwide Mortgage Company will sell the names of people that purchase houses to ADT, Lowe's, et cetera, because new homeowners are likely to need these services. I believe my only two options are to ask data subjects to accept the risk through consent or to discontinue. Thoughts? I disagree with that. Your only options really are to either go back to your customers, to the data controllers, and tell them what's going on, and either get them to consent or don't use the vendors. You're a processor, be a processor, go back to the data controller and alert them to this. By the way, this is not in any way unusual. I can't believe that I see it all the time. Companies will be a processor and they'll say, oh, I'm really a data controller, and they're not. And they can do whatever they want with the data, and they cannot. And I've had these battles endlessly for years. Be on the lookout for these things, and whenever you see this, call the data controller and say, hey, do you know what these guys are up to? It happens all the time. That's the last of the nailed in questions. I know we got about a minute left. Eddie, anything else rolling in before we wrap up here?
Yeah, there was a really, really good follow-up to the server storage with the
Yes,
EU and GDPR questions. So it says,
yes,
related to the server storing data in the EU, if the data does not include any EU resident data, does GDPR still apply? So you've got these
yes,
US
it does.
businesses, and yep, go ahead, Scott.
Yes, it does. I know that seems crazy, but again, it's on their soil. It's on their soil. Their law applies. And again, I know that seems crazy, but if you don't want their laws to apply, don't put the box or don't store it on the box on their soil, and you'll be okay. At least insofar as the GDPR is concerned.
And then another follow-up, isn't there a classification where a company can be a hybrid, where they are both a controller and a processor when the processing is shared?
I'm, that's a great question. I'm not aware of a company where you would be a controller of your data, but also be a processor of your own data. That doesn't make a lot of sense. You may have subsidiaries that are processors, and that's fine, but you're going to still have the same standards apply. So if the processor is in another country, going to have model contract clauses, or potentially, if they're here in the U.S., then have a privacy shield. The net of it is that even if you are a processor of your own data, if you have the control over the purposes and means, you're a controller, and you're going to be treated as such.
All right, well, thank you all very much for staying on. We are at 2 p.m. and we are done, and we want to be respectful of your time. If you have any questions, Scott's email is here, and he will definitely be available to answer anything that you have. And of course, if you go to Spirion.com, we have tons of white papers, resources, blog posts, a podcast that is now on iTunes called Privacy Please. And we hope that you check that out and our future webinars as well. Scott, would you like to say anything before we sign off?
Thank you all for joining. We had great turnout today, and feel free to email me if you have questions. I'll get back to you as soon as I can.
Great. Thank you all very much.